Hello, everyone. Welcome to Court with Krissy. Today, our OnlyFans influencer who arrived on vacation finds out if he leaves on probation. That's followed by Jesse Win Big Williams wanting to put it all on the record. I hope you like it. Court with Krissy is now in session.
Do you have any source of income or support?
Yes, ma'am. I do make some money from TikTok, and I'm a sole proprietor for OnlyFans. It just started to make money. I don't have an average. I've made about 100 so far this month. It's one of those things where you build up. I had just started it.
Well, Judge, I had met my fiance and her family lives in Chicago. And then I was being told that, due to the court case with my ex-wife and the divorce, that I wasn't going to be able to see my kids for about a year. I was running out of money from being left homeless after my ex-wife or soon to be ex-wife had removed me from the house. And I had saw that an Airbnb over this way was, only $2,000 a month for a refurbished or a pre-furnished unit versus, any place that I could find on the West Coast was $3,500 plus, need a background check. I had been out of work as a union carpenter for quite some time due to the economy, and I had brought my truck I had just purchased and about $13,000 in carpentry tools. I was trying to find work over here, Judge, so it was just somewhere more affordable.
So you came here for Traverse City, to Traverse City, primarily because you found this Airbnb, and before coming here, you were in Chicago, is that right?
Yes, Judge.
Okay, well, I guess, that's very interesting. So there were two other people in this Airbnb when this thing happened, and Ashley, Vanessa. Did you know them before this, or were they at the bar also and went back with you?
They were at the bar, Judge, and actually, Christopher and Christina had went to go get them after the fact that we had came to the apartment because they had called us. We had met them that night, but they didn't come over till after.
So this is so weird because, you're from Washington, you got pending cases there, pending in Illinois, you come here only because of this Airbnb that was affordable. You meet these two women and Mr. Can't remember what bar this was, Union Street Station. You all go back to, I guess, your Airbnb. Ms. Denacolo then decides to go upstairs or on the roof of the place to the hot tub with Mr. They come back downstairs eventually, find you in bed with one of these other two women that were at the bar with you never knew before. That's how this whole thing got started. Police show up, they attempt to arrest you, and you resisted for a bit. They're trying to take you into custody. They put you in the back seat of a police car. They say that you began striking the plastic protective divider of the driving cockpit with your head multiple times. They had to open the door and push you back into the seat, I guess, to keep you from hurting yourself. This whole factual scenario is just very strange. Magistrate sets a $20,000 10% bond. Ms. Denacolo pays it. This is just strange. Sounds like you're a public safety risk, frankly, with these two pending drug drivings, a pending DV that you never took care of in 21, so you probably absconded there. I don't know. I'm not feeling too comfortable with this, with Mr. Hoy being out. He's not from here. He's came here for the reasons he stated, just probably in late March or early April. I'm just not comfortable at all. He's pled guilty to assault and battery. I know there's more to this case. Probation will figure that out. But I think given all of these circumstances, he's no longer entitled to bond. So I'm going to remand him to jail until sentencing. He'll get credit for all the time he serves at the time of sentencing. Probably we can't put him on probation here because who knows what state he's going to go to next. So So you have to turn yourself into the jail here immediately, Mr. Hoy. We'll try to expedite sentencing as much as we can. So, all right. We're all set. All right, so we'll call the case of Mr. Hoy. So this is file 24-18-44 FY1, People versus Colin Richard Hoy. Date and time of sentencing. The conviction here is assault and battery. This was reduced from felonious assault, a 4-year felony. But Mr. Hoy, have you had the chance to review the pre-sentence report prepared in this case, sir?
I have, Your Honor.
All right. Is it factually accurate, or are there any changes, corrections, or additions you'd like to have made?
It is accurate, Your Honor.
All right. There is a victim's impact statement attached as well. Have you had the chance to review that, sir?
Yes.
Okay. All right. So then by way of elocution, Ms. Conlon, are there comments you'd like to make?
Yeah, I do have a couple of updates, I guess, to the pre-sentence report or correction. As of today, Mr. Hoy actually has 35 days credit time served. He was, his bond was set, let's see, he was arrested on April 5th and wasn't able to bond out until April 11th. And then I think that Ms. Hull's numbers are correct as of Monday. He had 26 days. So if we added 3 days to that, plus the 6 days he already served before he bonded out, it should be 35 days credit, Your Honor.
All right. So we'll accept that. Anything else?
Yeah, just Mr. Hoy's fiance's name is spelled wrong. It's DeNicolo. I don't even know what it says on the report, but under the special bond conditions of having no contact, which you did lift that, you lifted that provision at our last hearing, but it's DENICOLO.
Yeah, in the rest of the report, it's spelled correctly.
Correct.
Okay, all right, but I'll make that change at the top of the report.
I think that's all the changes that I had, Your Honor.
All right. So then by way of elocution, are there comments you'd like to make?
Well, Your Honor, I think that, and I think that the court needs to be cognizant of the fact that Mr. Hoy has never had a criminal conviction before. He does have the 2 matters pending, one in Illinois and one in Washington, that I know caused the court great concern at the time that his bond was revoked. However, I wanted to make it clear he is not absconded on those matters. He has attorneys in both cases. He's attended Zoom hearings. He does have a Zoom hearing coming up, as is set forth in the report, on May 29th on the case in Illinois. He's not out running around committing crimes, okay? He did go through a very low point in going through his divorce. He admits that he engaged in some behaviors he shouldn't engage in. He's in the last month that he's been sitting continuously in jail. He's gotten a lot of insight into that. He's got good plans going forward. Even once he was charged with these offenses and knew he had to remain in Grand Traverse County, or in Michigan anyway, where he hadn't intended to remain, he got a job. He was working. He was working for Painting by Dan. He was making good money. He's missed out on about $4,000 worth of work over the last month being in jail. This is not a guy that's just running around indiscriminately committing crimes and absconding, Your Honor. He is taking all of this very seriously. In his statement to Ms. Hull, he was very remorseful for what happened here. I think all that needs to be taken into consideration. He's a carpenter. He can get back to work very soon. He's in a union. I think, Your Honor, that the appropriate remedy here is to sentence him to time served plus appropriate fines and costs. He intends to, once he's done with his obligations to this court, he is going to go deal with his other matters and hopefully get those resolved. So I just ask you to consider that, Your Honor. Thank you.
All right, thank you, Ms. Conlon. So, Mr. Hoy, those are very good comments and very good points that Ms. Conlon makes. But are there comments you would like to make, sir?
You're asking me? Sorry.
Yes, yeah, go
Yeah.
ahead.
Yeah, I regret what happened, Your Honor. I've been struggling with the divorce. I wasn't thinking right. I've let your courts believe that I was acting like somebody I'm not. I am a very accomplished Finnish carpenter, father of 3, very proud father of 3 beautiful daughters. And I think maybe I was begrudgingly going down a path that I wasn't really recognizing who I was. And I've had time to sit through that. And I have been in contact with my other attorneys. I would just like you to consider that this is the time of the year where most of the companies in Washington are hiring for my type of work, and this is the time of the year I do make most of my money, and just being in here has been financially detrimental, and I will have some making up to do, but I plan on doing the right thing, and I am sorry I have caused your town some trouble, sir.
Okay, so I appreciate your comments. Are you planning to then go back to Washington State? Is that what you're going to do?
After Schaumburg, Your Honor, I have a hearing in Schaumburg on the 29th, and then I will be returning to Washington, yes.
Okay. All right, well, you, like, as Ms. Conlon pointed out, you don't have any prior convictions. You have those 2 pending cases, but I can't consider those. When you were remanded to jail, you went to jail, you obeyed the court order. I think this entire incident seems like it's out of character for you. And otherwise, you have a lot of positives going for you. So I think what is appropriate in terms of a sentencer is no probation, $100 fine, $500 court costs, $75 convictions fee, $50 state fee, $700 attorney fee, and then credit for all time served. So you'll be released today, so you can head back to Illinois, start there, and then eventually to Washington. Okay.
Thank you, Your Honor.
All right.
Thanks, Your Honor.
Yeah, thank you. You're all set.
Good luck. Good luck, Colin.
Should I just get up and?
You're all set.
Okay.
You're all set.
All right, thank you.
Do you have a matter, Mr. Williams?
I do. I have a pretrial form that I'm going to submit to the court shortly, but I want to make a record of it with the court. So if I could have my case called, I do have a matter.
I don't know what your case is because it's not checked in.
That's right, but I've submitted
Checked in.
but I'm not doing a plea today. So I'm asking if I could address my case. I'm in court. I'm a court officer. I'm asking you if you will call my case so I can address my case. I need to make a record. So if I could do that, I would appreciate it. I need to address an issue with the court. So we're talking about a form. I'm standing physically in the courtroom.
Yeah.
And
I
have a form in my hand.
am not going to cater to you. I am not going to indulge you or engage with you. We all know what this is about. You need to speak to administration. The administrative team has made a decision.
I don't know what that decision
your
is.
issues.
Can we go on record, please? Can you please call my case?
If you aren't listening to me, you're treading on thin ice. I'm not going to talk about it today.
I'm going to submit this form, Your
You
Honor.
can submit it in writing.
No.
Your complaints.
It's not a complaint. I'm submitting a pre-trial form that's going to be set for a plea.
That's not how it works. It gets turned into the.
form says.
So,
I'm just asking.
Mr. Sheffalo, come on up, please. Go turn it in, Mr. Williams. You want me
I
to
will-
address your case?
Excuse me, Your Honor.
Go turn the form in and we can address your case.
Oh, perfect. Thank you. You could have said that in the first place.
I did say that in the first place.
And then
Okay.
Your Honor,
Yes.
I have, if I could, while the prosecutor's still here, I have some pre-trials that were scheduled for tomorrow.
Okay,
I did submit STIPs to set them for pleas. We already conducted the pre-trials. We have the offers in the STIPs. And the court's not available tomorrow for pleas regardless. So we received back from the court just a blanket. Judge Stepka denies this, typed in. I don't know if you've ever seen them. They said they're going to re-present them to you because they said there weren't offers, and I asked them to look at the language in the STIPs, the court, not the prosecutor. The prosecutor signed it. So the point I'm getting at is there's 3 pre-trials scheduled tomorrow. I've submitted the substance abuse assessments. We've already conducted the pre-trials, and the court would not be available tomorrow to take the plea. And if I were to drive there, for multiple reasons, I don't need to get onto this record, it would be very frustrating. Then my clients would take time off of work, drive there, and we would get nothing accomplished. So we submitted STIPs to the court to set them for adjourn the pre-trial and set them for pleas because we've resolved the cases. My office has the prosecutor's office previously. So I don't know if they could represent them to the court. We're just simply asking for a plea date so we could get these cases resolved. They're 3 misdemeanors.
okay, so I have seen them. I've talked to Sue Shaw. She came to see me today after I talked to her on the phone. And then I talked to Judge Cooney about them too. It's against the policy that we have. And everyone was told that well, 2 Fridays ago when we met out with our defense attorneys and the prosecutor.
So I'm going to file a motion. The people already told me they won't object to it. And frankly, it's I have a disability. I have a birth defect that caused a disability, that caused a disease. And frankly, this policy, the prosecutor's office doesn't send the attorney who's trying the case to the pretrial, as the policy would indicate. The policy also indicated the court would be available to take a plea. So the court would be in violation of its own policy and not enforcing it properly in every direction here. So tomorrow, I would drive to Traverse City unnecessarily with degenerative disc disease causing pain to myself, have my clients drive, take time off of work, have their employers deal with that, find childcare, to what? Sign a form for a pretrial that we already conducted, that the court would not be available to take the plea on regardless. So
We have a judge tomorrow.
I was told by the court wasn't available. So that being said, Your Honor, we've already conducted the pretrial. The policy allows for pleas to be taken by Zoom. The policy does. So why can't the court schedule these for pleas tomorrow? I'm asking the court. I have a disease. I'm a veteran. I'm one of the most organized attorneys you deal with. I've taken the time to resolve these cases as all attorneys should ahead of time properly. I have in writing the resolutions. Why can't I schedule these for pleas tomorrow then by Zoom?
Well, so it's the policy. There are no exceptions.
Okay, well, I'm going to ask you then, Judge Stepka. I've approached you. I've shown you my back. I've shown you my MRI. You know that I have degenerative disc disease. I'm making this record. Then I would like you to adjourn all my pretrials tomorrow. I want to file a motion. I believe that I may have an ADA claim. I am not going to be treated this way. I've been practicing here for almost 20 years. As I stand here and talk to you today, I have sciatic nerve pain shooting down the left side of my leg into my buttocks. I have pain in my neck, and I have tingling in the left side of my face. I am not going to tolerate this treatment any further. So will you adjourn my pretrial so I can file the proper motion and make the proper record? This policy that you refer to is flawed. You don't follow the policy.
Okay.
Judge Cooney doesn't follow the policy. I'm making the record. Tomorrow, the prosecutor's office will not have.
Hang on. I'll adjourn so you can file your motion. Okay.
Thank you.
It might be easier if you just talk to the court administrator and filled out an ADA request form. I think.
Well, why didn't someone suggest that a long time ago?
Well, I don't know. I think somebody said they did, but.
No, they didn't. You know what? In fact, this is what happened. Now that we're making a record, I was at a bike store, McLean or Brick Wheels, and someone from the court saw me there, and then went and told the judges, "Hey, I saw Jesse Williams at the bike store. Ha ha ha! His back must not hurt so bad." You know, the way I've been treated by people here is appalling. Frankly, appalling. No one suggested anything helpful.
Okay.
Everyone almost like ridicules and acts as if I'm making it up.
I'm giving you what you requested, okay? So, and actually, these cases are not on the docket today, so I've let you go on and say what you wanted to say.
Yeah.
But, you know, we're not on the record in those other cases.
But
So go ahead and grant your adjournment.
Thank you.
I think you should contact the court administrator about making an ADA request. I think they go pretty quickly. And then there wouldn't be a need for a hearing, okay? So that's what we'll do.
Okay, I'll do that. Thank you. I appreciate the guidance. Thank you. I will contact court administrator right now. Thank you.
Okay, thank you. So we'll go on to the next case. Margaret Sandoval, file 24, 1926 FY for 1892 SD1. There's a pretrial conference today. Mr. Heflin and Mr. Williams are here in person. The plea offers to plead guilty to operating while intoxicating. The people will dismiss count 2, which is reckless driving. So, Mr. Heflin, is that what you intend to do or not?
Yes, Your Honor, I would like to address the court. We did not conduct a pretrial conference this morning, so let the record reflect that. I conducted this pretrial prior to court today. In fact, the prosecuting attorney who's assigned to this case is not at the pretrial. In fact, that occurs routinely in these pretrials, contrary to the process that the court has outlined. A prosecutor shows up, not the assigned attorney and not the attorney trying the case. So we did not conduct a pretrial this morning. In fact, I submitted a stipend order, which was signed by the prosecutor's office to set this for a plea. My client still needs a substance abuse evaluation. About a week or so ago, I went on record with you. I asked to order that transcript. I expressed to you again my frustration. I've been asking for an accommodation. I've heard the word come back from, I don't know if it was you, but I know Judge Cooney. I won't make an exception for you, Mr. Williams. I don't want an exception. I don't need an exception. I'm one of the best attorneys that this court deals with. Never need an exception, just want an accommodation. I have a medical history. I have a birth defect, I have a chronic disease, and I have chronic pain. Even as I talk to you right now, my face is twitching, it hurts. And I drove up here because you refused to sign a stip for me because of a policy where I'm asking for an accommodation. The court administrator here acts as the ADA coordinator. I explained to the court administrator, per your suggestion on the record, for an accommodation for an ADA accommodation. The court administrator, who also sits as the ADA coordinator, clearly didn't understand my words or read the form because they sent that off to a law firm down in Lansing who billed this county for an opinion that had nothing to do with my request. So again, I'm making this record because I intend to see this through. I've been mistreated. I've been treated rudely, frankly, okay? I don't need an exception. I don't ever want to hear the word exception again come out of anyone's mouth towards me because I work hard. You know I work hard, and you know I'm ahead of my cases. And I simply could have had a form submitted and not drove up here today and spent several hours now driving, like I did earlier this week, where I came up here for 3 other pretrials where you weren't available. I don't care, but you weren't available. And frankly, this process bills the county. Now you have court-appointed attorneys spending hour and a half, 2 hours here, wasting time billing the county when they could have spent 15 minutes on Zoom resolving this case. Talk to the other attorneys out there. We all pre-try our cases. We don't randomly show up to a pretrial date. Let's think about this process because this process needs to be known. Today, the prosecuting attorney's office walks from their office with a random attorney that walks into the courtroom, goes to the clerk's window and gets a stack of pretrials, probably 40 thick. That attorney only knows about what is in those forms related to that attorney's case only. So now that attorney will go into a pretrial room, look on their computer and see a recommendation from whoever is assigned to the case. Any attorney that's doing that, in my opinion, is committing malpractice, that is showing up for the very first time, accepting a form, and then going back and telling their client, you better take this plea. In fact, I asked to have this set for a a video conference hearing per the form, and that still was met with resistance. In fact, the court administrator told me when we spoke in her office that you guys could amend that form and that wouldn't even be an option. Again, I don't know what part nobody's hearing. This is cruel. It's rude. I have a birth defect. I have a disease and I'm in pain. And I simply could just resolve this with a form, which I've done for several years, hundreds of times. I've showed you my MRI. I've showed the court administrator my MRI. I've showed the court administrator, who also acts as the ADA coordinator, which is a bizarre situation, my MRI. What do I need to do? Do I need to figure out how to sue this court in circuit court? Do I need to figure out how to sue this court in federal court? I've been in front of you for almost 20 years. You know me. I work super hard and I am super dialed in as an attorney, and I do very well for my clients. The fact that I'm standing here is infuriating. It means that you guys don't care about my back. In fact, I had someone rude enough to say, oh, I saw Mr. Williams in the bike shop and went and told the circuit judges. And then that was brought up on record. Oh, well, here you're at the bike shop. Am I supposed to live like in a dark closet somewhere because I have a disease and not have any type of life? Am I supposed to like drive up here because of a personality problem? And that's what this is. It's a personality problem. It's not logically thinking. If someone, I can guarantee you, if a federal judge with some cognitive ability were to review this and said, hey, you guys really wouldn't allow this attorney to submit a form that has been doing this for years, that is never missed one, per your own staff said, my office in particular, and you were at that meeting, was ahead of everyone and always submitted the form, and they never had a problem with me. What is going on? Seriously, what is going on? I'm laying on the floor at night. What part about that is anyone not getting? I go home, I gotta lay down on the ground because my face hurts, my back hurts, my legs hurt. I don't want surgery. I want to get through this. I've been in physical therapy now for on and off now for 14 months. I just got another MRI ordered last week. What gives? I mean, you have the discretion, but you know that opinion that this county wastes their money on with that law firm, they cite an unpublished Sixth Circuit opinion that, well, let's waste some more money. But nonetheless, it says the court can give a accommodation. It doesn't have to give the specific one I'm asking for, but to give a accommodation. I could log in on pretrial days, Your Honor, and pre-try a case with the prosecutor. They could send me the form. They could submit the form. I don't understand this. It doesn't make any sense. Honestly, I hope that the county commissioners review this record and realize now with this policy in place, you have a two-pronged effect. You have one, it costs the county a lot more money because now attorneys are coming here, court-appointed attorneys, billing hourly for pre-trials that they already conducted. And I did speak to some of the attorneys this morning and they had conducted their pre-trials. So now the county's wasting money. And then two, it discriminates against poor people. And that issue, I think, is a bigger issue than my problem. Because what that does is that allows attorneys who are not looking at their cases, not looking at their discovery, and again, that was brought up at the meeting, and you know that there are certain attorneys that are doing that, and the prosecutor confirmed that at the meeting. They show up today, they walk into a room where an attorney is sitting, a prosecutor, they get handed a form, here's your offer. They never once spoke to the attorney assigned to the case. They never once even looked at their discovery, and they walk back out to a poor person who has no voice, no money to hire someone like myself, and they say, here's your offer, you better take it, you gotta take it, it's a good deal. And they never spend 1 second learning about that case. So this policy not only costs the county money, it discriminates against poor people, and I don't know what the heck's going on with me. I mean, I have a freaking disease, I'm in pain, I'm not doing well, I'm asking for some help, I'm asking for an accommodation. And what is going on? And I do think it's personal. I don't think Gwen Taylor likes me. She didn't like me. I'm going to say this record, and this will flush out.
I have to get moving. I'm giving you a lot of time here.
It's good because I want
concern.
Right. So why didn't you sign my stick? It was signed by the prosecutor. Why didn't you on the record? Why didn't you sign my stick? You know all these problems I have. Why didn't you sign it?
I don't have to answer that.
But you do. Why didn't you?
I don't have to answer that, but you know the policy.
I don't want what policy? What policy?
We met a month ago at the courtroom.
Is that the policy
And
where Judge Cooney?
So Judge Cooney told all the attorneys what his decision as chief judge and the administrative team have decided on.
Okay,
in-person
is,
income. So that's.
so you're telling me
that's
because of
what
a
it is.
policy, you don't care about my medical problem? Is that what you're telling me? Because that's what I'm hearing.
I'm not saying that.
You have made comments about me, okay? Judge Cooney has yelled at me. If you want me to put this on the record, I will. I will. And I'm starting to think this is personal. When Taylor doesn't like me, one of your clerks that worked here told me very explicitly some comments that were made about me. Judge Cooney's told me to shut up on the record. And now I'm asking for an medical accommodation, which if anyone else other than the three of you who doesn't know me would look at this, look at my MRI and be like, well, what's the big deal? And now here I am again. You're telling me you won't. Are you autonomous? Are you a judge? You can make your own decision. You know what's going on with
All
me.
right, so, I've
But-
been way too much. You're getting off track.
Okay, so
this-
why can't you help me
your-
with my situation?
Your issues, Mr. Williams, are not on the docket today, okay?
What do you mean?
I've given you plenty of time.
We're here.
I have to move on.
So can you set this for a plea then for my client so we can get his substance abuse evaluation? As the form suggests, set for a plea, I turned it in. And I'll be back and that'll avoid one more trip. But again, this doesn't rest here. So I'm gonna order the transcript. You're telling me that you are not interested in my accommodation.
I'm not saying that. You can do whatever you want to do. And I've told you over the years how many times that I know you're a good attorney. You do a good
Then
job.
why
So,
am I getting this? Then why am I having this hard time? Why?
well, all I can say, Jesse, is the chief judge has made a decision
You don't have to follow this.
along with the administrative team.
You're the judge.
So anyway, Jesse, I'm sorry. To do.
So my question is, can this be set for a plea? My client's here.
All right, we'll call the case of People versus Patrick Henry Heflin, file 24-1892 SD1. There's a pretrial conference today. The plea offer, Mr. Heflin, is you plead guilty to operating while intoxicated, first offense, a 93-day maximum misdemeanor with driver's license sanctions from the Secretary of State. Count 2, reckless driving, would be dismissed. So do you wish to accept that offer and plead guilty? All right. You're not on any probation or parole, right?
No, sir.
Other than this offer from the prosecutor, has anything else been promised to you, or have you been forced, threatened, coerced, or had anything done to you to make you plead guilty against your will?
No, sir.
All right, you've gone over all of your rights to trial then with Mr. Williams. Do you understand those trial rights?
Yes, sir.
Understand that by pleading guilty, you're giving up those rights, you won't have a trial?
Yes, sir.
You do understand the license sanction from the Secretary of State, is that right?
Yes.
All right. And if you could not afford Mr. Williams' services, the court would appoint a lawyer to represent you. Do you understand that?
Yes, sir.
All right, so the information here states on or about April 7 of this year, Grand Traverse County, US 31 North and Bunker Hill Road, you were operating a motor vehicle, is that right? Were you pulled over by the police or did you have an accident?
Hold
All right. And when they had contact with you, they thought you might be intoxicated, so they ran you through tests there at the scene. After those, you were arrested and had a intoxilizer breath test at the jail, is that right? There were 2 readings there, 0.168 and a 0.166. Do you have any dispute with those results? All right, so I'll accept the plea. We'll dismiss count 2. All right, we're waiting for the assessment. So, okay, please accept the count 2 is dismissed. Let's see.
He's scheduled for an assessment on the 30th.
Right, right.
Friday. I'll have it most likely that following Monday. I can get it to the court. His prior history, I don't know if it's on there anymore. He had marijuana as a misdemeanor.
Okay.
Those, I believe, most of those have been removed from people's
All right.
records. So, and he did travel during bond out of country, no issues. I mean, he's hasn't any issues. I would just simply ask if I could schedule it of sentencing by Zoom. That's why I wanted to adjourn this, so I could have done the plea and sentencing. And it's just one, now that's 2 trips. It just keeps adding up. And that's why I'm really frustrated, because I don't think anyone really cares. I think that there's a policy, and that's the only thing that anyone cares about. So,
All right, so we'll continue the bond. We'll set the matter for sentencing. I will refer the case to probation for pre-sentence investigation, sentencing recommendation. We'll note that the substance use assessment's being done. You have to provide that to probation once it's completed.
sure.
And again, bonds continued. Do we have a sentencing date?
Sentencing would be June 28th at 9:45.
Is that something that I could do on Zoom?
No, they're in person.
But you've approved it before. And if I would have set this by plea, you would have sentenced. And if I would have had a substance abuse evaluation, just like the case you just did before mine, you would have sentenced. And again, I will say it's personal, because you know these things, and you know this is causing difficulty for me. And you know I've been making this request, and there's no reason why you couldn't let me do it hundreds of times. I don't know why I can't do that. What date was that?
June 28th at 9:45.
All right, so we'll go on to the next case.
I have a bench trial that day in circuit court, so I can't do it by Zoom.
It's in person. The sentencings, are in person. There've been some exceptions that, yes, I've given you a chance to be there on Zoom, but
It's a first offense, not
that was
serious.
then.
It's a
So
first offense, not serious misdemeanor.
it's still a sentencing though.
But how many times have we proceeded to sentencing after plea, just like you
So-
did today?
So I'm just not going to debate this.
Can I just ask you this? Is anyone gonna get back to me about my issue, or can I consider that you guys are just ignoring it at this point?
You'll have a decision from the administrator, I think, relatively soon. So.
I was told that, like, on.
Well, I
Tuesday.
can't do anything about it. Okay, I have to move on with my docket. So thank you.
right.
Mr. Travis, then you have Mr. Hershey.
Yes, Your Honor.
What date are we doing sentencing?
What about that Monday, July 1st? That'd be 9:15.
Right. So this is file 24-1064 SM1. It's the date and time of a scheduled final conference. Mr. Travis and a bench warrant issue. But Mr. Travis, how does Mr. Hershey want to proceed on the bench warrant?